When you left the house this morning, you surely didn't expect to be arrested for a crime. Sirens, lights, handcuffs, the entire process was undoubtedly one of the most stressful events of your life. You breathe a sigh of relief because at least you were released on citation and only charged with a misdemeanor in the District of Columbia. Now what? My name is Joseph Scrofano and I'm the founder of Scrofano Law PC, a criminal cannabis and DUI defense firm that represents individuals under investigation or charged with a crime in DC, Northern Virginia, and Southern Maryland. And in this video, we're going to be discussing how to navigate a misdemeanor case in DC Superior Court. Now, while anything short of making the entire situation disappear won't make you feel better, knowing what to expect about the legal process ahead of you might relieve some of the stress you're experiencing. In DC, offenses such as DUI, simple assault, solicitation of prostitution, and hit and run are all charged as misdemeanor, which means they carry a maximum penalty of less than 1 year in jail. We'll do a separate video for felonies. Having a criminal conviction on your record will have a lasting impact on your life. This is why one of the first things you should do if charged with a DC crime is contact a criminal defense attorney. Now, the next step in the process is called the arraignment. At an arraignment, you and your attorney will go before a judge who will inform you of the specific charges filed against you. During this stage and at this hearing, you will enter a plea of not guilty. Your attorney should assert your constitutional rights, and the judge will typically impose release conditions. Now, there are a variety of conditions the judge may impose here that require you to do or not do certain things. In every case, the judge is going to order you to verify your address with an agency called Pretrial Services, which requires you to submit a piece of mail postmarked within 30 days to that agency. For cases where there's a victim or what we defense attorneys call a complaining witness, the judge will typically order you to stay away from that individual. In many cases, the judge may order you to stay away from a location in which the alleged crime occurred. Other conditions may include drug testing, drug or mental health treatment, and/or reporting to pretrial services once per week by phone or in person. Now, you might say, well, why would I plead not guilty at the arraignment if I am guilty? Maybe you were arrested for driving with a suspended license and you were in fact driving with a suspended license. However, it's extremely rare for someone to enter a guilty plea at the arraignment. There is almost never a reason to do that, and if you ultimately do plead guilty, it's usually going to be after your lawyer negotiates some type of plea agreement with the prosecution, not just throwing your hands up at the first court date and saying, I give up, I'm guilty. Now, during the pretrial phase, you and your attorney will work together to build your defense. At Scrofano Law PC, we call this phase the investigate, negotiate, and communicate phase. We independently investigate the allegations against you. We receive discovery from the government and discuss what type of plea or diversion options the government might offer. Now, we've previously done a video explaining what diversion was in a criminal case and how that could be your best option if available. So, in short, we investigate the allegations, negotiate with the prosecutor, and communicate with our clients throughout this phase. Now, periodically, you may have to go before a judge for what are called status hearings. These hearings keep the judge up to date about where the defense and government are in their case preparation. The time spent in the pretrial phase is largely dependent on the facts of your case. The more complicated the facts of your case, the longer the phase will last. It's also during this phase your attorney may also file some pretrial motions. These motions are usually filed as a chance to get some of the government's evidence against you dismissed, or maybe to compel them to produce evidence they haven't produced. Additionally, the government may offer plea bargains at this step in the case. Whether you should take the plea bargain is entirely your decision, but your attorney is going to help guide you the decision and advise you what could happen if you do or don't take it. Assuming you don't take the plea offer, the next stage in the criminal process is trial. At trial, the government has the burden of proving beyond a reasonable doubt that you committed the crime charged. What that means is the government has the sole responsibility of presenting evidence and persuading the finder of fact that you are guilty. The finder of fact may be a jury or a judge, depending on your case. In DC, you don't have a right to a jury trial if you're only facing up to 180 days in jail. Yeah, only 180 days. Instead, your trial will be conducted before a judge, and the judge will decide your innocence or guilt. You do not have to testify at trial. You have an absolute constitutional right not to incriminate yourself, and the government is not allowed to argue your guilt based on your silence. They can't say, well, he didn't testify, he must be guilty. Whether you should testify at trial is solely your decision. However, your attorney should advise you to help you weigh the risks and benefits of testifying. In the unfortunate event that you are found guilty at trial, the next step in the process is sentencing. Sentencing in most misdemeanor cases will happen on the same day as trial. Although, if there is a complaining witness in the case, the judge may continue sentencing for a few weeks to get what's called a victim impact statement. Here, the complaining witness gets an opportunity to tell the judge how the crime may have affected them personally. Similar to trial, the government will present evidence during sentencing and make arguments to try and persuade the judge to give you a particular sentence. Sentencing is as important as the trial phase, and sometimes even more so. At sentencing, you will also have a right to say something to the judge in advance of the judge meting out the sentence. Similar to trial, you have an absolute right to say something here, but also have an absolute right not to. Finally, the judge has a legal authority to give different types of sentences. Some sentences in misdemeanor cases will include just straight jail time. Maybe, for example, 30 days in jail. Other types of sentences include a mix between jail and probation. A sentence could be, for example, 90 days, execution of the sentence suspended as to all but 20 days, followed by 1 year of probation. That means you'd have to spend 20 days in jail and then 1 year of probation upon release. Finally, a judge could just give a straight suspended sentence with probation. So the example might be the 90 days, execution of the sentence suspended as to all with 1 year supervised probation. In addition, probation can include conditions like community service, substance abuse, mental health classes, stay away orders like we mentioned at the pretrial stage. So if you or someone you know has been arrested in the DMV area, contact us today for a free consultation. Or if you're just interested in learning about criminal law topics, go ahead and hit the like button and subscribe to our channel, where we will continue to post new videos on criminal law topics each week.